Anyway, our conversation today is going to be about justice, access to justice, and the transformational ways of accessing justice, like this new one called the Small Claims Court, which was actually touted as one very good way of, if you have a claim from a shilling to 1 million shillings. I don't know whether it's a million or it's 999,999.
Right.
The Judiciary Spokesperson, the Honorable Paul Ndemo, is our guest. Good morning.
Good morning.
Asante sana for joining us.
Thank you.
So first of all, is it up to a million or is it just below a million?
Up to a million.
Up to a million.
Yeah.
Up to and including a million.
So 1 million and one can't.
That's
okay.
out.
Okay.
Just remove that 1 shilling and you are
And
in
you're
business.
And you're in
If
business.
I'm willing to forgo the 1
You
shilling.
can forgo the 1 shilling.
Okay. Let's get into.
You know how the drill goes?
Yeah.
Janice with the quotes.
Yeah, today's quote is centered around health justice, and it's from Paul Farmer, who was a giant in global health. He once said, if access to healthcare is considered a human right, who is considered human enough to have that right?
Wow. That should be everybody.
Right.
Everybody's human.
Yeah.
So everybody has got, you know, a right to then have that access.
Yeah.
Yeah.
Well, we would hope so.
It's
But
supposed
then
to be
there's
that.
always
Yeah.
those who are considered less human than others. Yeah.
Yeah.
We're just denying them their right. Right? Right?
Right?
Right.
You did that.
Right.
Pun intended.
Pun intended.
Honorable Ndemo,
Yes.
there was a complaint that was out there and it has received quite a bit of reaction online. It was posted by Advocate Harry Karanja, who on X said, posted it with RIP Small Claims Court. And he said, the Small Claims Court is dead. Small Claims Court was built on 3 premises. Fast, simple, affordable. The tragedy is that each premise has been dismantled partly by court decisions and partly by internal practice that drifted back into the old magistrates' courts culture. He goes ahead to give, for example, fast, fact, fast. First, fast. Okay?
Right.
He says, this, it was designed around speed. Timeline was meant to, you go into this court and you get your judgment and decision within the fastest time possible. However, there have been some cases where, for example, a case where he quotes Justice Majanja in a case treating the timeline as directory and not mandatory. And it goes on to say, now, by such, it means that this is, it's a suggestion that we should have these cases heard and determined within, is it 6 months?
60 days.
60 days, yes. The second one, simple. He says, there's also the same judge in another separate case pushed rent arrears out of small claims court, one of the most common small disputes in urban Kenya. That alone made the court less simple because litigants are forced into heavier forums. Simplicity also died from inside. Many adjudicators imported magistrates' court habits. Written submissions became routine, even when the model was meant to be conversational and evidence-led. The 3-day post-hearing judgment timeline became optional. Exemptor judgment templates that Justice Kimaru has suggested during training colloquia were ignored, and so on and so forth. It was supposed to be simple. Third, affordable, meaning affordable to win, affordable to enforce. A cheap judgment that cannot be enforced is not affordable. It's a paper trophy. Another case here, Ogwari versus Hersey, in July 2023, created serious uncertainty on road traffic injury jurisdiction. Then in 2026, last week, 22nd of January, a 3-judge bench, Ogola, Nyakundi, and Mabea, closed the door on road traffic injury claims and removed committals as an enforcement tool in the small claims framework. Enforcement was blunted at the exact moment that demand for this was rising. So basically this lawyer and others who've commented have said, yeah, it was meant to be simple. Now it has become so complicated. It is simple no more. What says you?
Very interesting. I think if we just start first from the latest decision, the court decision, that court was meant to cure some of those issues. So I think to start from the point of saying that it is now dead, nothing could be further from the truth. The very reason why those cases found themselves to court is simply because, you know, being a new court and there were new things there, you can expect people are trying to experiment and find out, so can this matter be brought here? Can this matter be brought here? So if you take the example of the road traffic accidents, they were starting to actually inundate the court. And those matters, by their very nature, are not very simple matters. So a matter like that, somebody may require to call medical evidence. You may actually even have to call a second, maybe a doctor to come and give evidence. You may have to go and carry out an investigation. So by their very nature, those matters are not that simple. But because it was a new court, these things were being tried and courts were making decisions. But now on a 3-judge bench, the matter was adjudicated there, and the court found like these matters should not be in that court. And so by just removing road traffic accidents itself brings back a lot of simplicity into the court process itself.
What's complex about road traffic accident cases? Just give us examples. Like, I know you've mentioned something here, but let's go practically. An accident has occurred. There's injury, right? And someone is claiming compensation for that. And their compensation they're claiming is less than 1 million shillings. All right? So I go to court. What's complex?
So it's, let's say it is, let's use the word complex relative.
Okay.
Yeah. Relative in the context of the small claims.
Okay.
Because if you are looking at trying to resolve the matter within 60 days, the idea, and as you read that tweet, the idea is that when you come to this court, it is as simple as Janet came to my kiosk. You know, she got some goods from there. I gave her goods worth 20, 30,000. That was 2 months ago, 3 months ago. She has refused to pay, and I've come here so that I can get my judgment. Is that true? Is that not true? So 1 witness, 2 witnesses, that matter is resolved within, within a day or 2 days. That is simplicity. Now, you come to a road traffic accident. Somebody has to come and prove that there was negligence.
Okay.
So that is one, and that is a full hearing. Somebody must come and say, this is what happened. I was driving on this side. This other person was on this side of the road, or I was in this vehicle, whatever. Apart from proving that there was negligence, you must call a doctor to come and produce or adduce evidence to show that this person then maybe suffered some injury, and therefore this is the report that shows there was that injury. The other person might contest that and say, no, the issue of, first of all, the issue of negligence, I don't agree with it. So I have an independent investigator. I want them to, there's an investigation they need to do on 1, 2, 3. So I want to call them to also come and do this. Then you're told, okay, fine, you come and give this. That is going to take maybe another month.
Right.
Then there's a contest about maybe the medical report. So you need a second medical report to come, and then a doctor to come and give evidence. When you combine that process, the issue of simplicity then goes out of the window. So it takes a little longer than what was anticipated. Because by the very nature of small claims, I mean, it is small claims.
Yeah.
The money is 1 million, yes. But even how you arrive at that compensation or that figure or that jurisdiction, as we call it in court, then has to be a process that is not so complicated. And that was the thinking behind the formation of the small claims court.
Yeah. So accidents, you kind of it was decided these are too complex for small claims.
Yeah.
Is there concern that other disputes, again, might be studied and also found not to be suitable for small? First of all, what disputes dominate? Let's say top 3, 4 disputes that dominate small claims court, and which ones who could perhaps also run the risk of becoming complex relative. Is it complex relative? And then now, before you know it, the small claims court is. So which ones dominate?
So it's largely what you might call civil and commercial disputes. So things like, money owed.
Yeah, like the example you just
example I just gave, borrowed money under that figure. You've got simple things like also what I mentioned, someone comes and maybe destroys a property that you have, but small amount of money, and it's something that you can adduce evidence, So the issues about particularly on debt owed, money owed, simple things like what we call in law tort. Let me explain that. That's so like you've caused an injury to somebody, but it's not an accident. Those are the main things that dominate the small claims court, because it's mainly around business, something that you got from somebody, a service that you rendered, somebody did not pay for it. So that is really it. It is unlikely that we'll have other matters that are considered complex, really, for what is there right now. It is unlikely. But of course, I can't speculate what will come in the future. But what is there currently, it's mainly along those lines. And so if a matter, falls within those parameters, then it's something that is heard by the courts, and that should be done very quickly. Yeah.
Before we go back to, because that tweet was very step by step, one by one. In your view, what's working with the small claims court right now? What's not working?
All right. First of all, if you just look at the numbers don't lie. This court was established in 2021. Between 2021 and now, we have over 280,000 cases that have been filed in that court alone, small claims court. Last year alone, we had over 150,000 in 1 year. So it means there is a pickup. There has been a very serious uptick of those of that court, matters done in that court. Yeah. There's a lot of confidence in that court. In fact, there is one county we visited in our routine checks, and the people there were saying, the most powerful court in this, and it's a big town, is actually the small claims court. And the reason was that in that small claims court, you're able to dispense justice very quickly. So that is a big, big, big deal. Though, of course, sometimes, as was read, there are times when that 60-day has been a challenge. Yeah. But the fact that one is able to have justice delivered within 60 days or thereabout is a very big deal. So people are able to say, if you go to that court, this is going to be resolved. And people want quick justice. Yeah. So I would say that the issue of that quick turn around time, save for exceptional cases, is a very, very, very big deal. Okay. The other thing, of course, is that the small claims court is 100% virtual. 100% virtual. And that means that people can log in and have access to the proceedings of that court from wherever you are. And that then makes it very easy. So even in terms of cost, in terms of convenience, of going to the court physically, it makes it that much easier and that much more accessible for Kenyans across the board. Right. So I would say, if you look at the numbers, if you look at the mode of delivery, if you look at the interest, very, very many lawyers are actually in the small claims court because there things move fast, and you are able to resolve things in that manner.
Oh, so you are allowed legal counsel in the small claims court?
Yes.
Can you go without it?
Yes.
Okay.
Yes.
So you can represent yourself?
You can represent yourself. Actually, the original thought, if I may, was that this was a court where people would come and just represent themselves without even having legal counsel. Right. Because without legal counsel, then, you just talk, you owe me money. Did you take it? Did you not take it? The adjudicator asks you, is this true? Is this not true? So devoid of the complexities, the legalese and, those kizungu, written submissions and objections, and because those are some of the things that now tend to take this long. And if I may just go back to the accident, the road traffic accidents, you see there, invariably, the parties would want to have an advocate, because in some of those you're dealing with the insurance companies themselves. They have an interest. So we must test and we must defend our right as far as possible because there are financial implications.
Right.
And that then has got those implications of time and delivery. But yes,
So that's-
counsel is allowed, and very many counsel, as I said, actually practice
In the small claims
in the
court.
small claims court.
Okay,
yes.
that's what's working. What isn't working?
So I think one of the big challenges we found, which was unexpected but is positive, is that the numbers were very high. If you look at the total number of cases that were filed last year in the entire judiciary, in the whole country, was 621,000. Small claims court alone,
150.
158,000 alone in 1 year.
Right.
Now, small claims courts are we only have 40 claims court, small claims across the country. So you can see the volume. The volume is so high. And so one of the immediate challenges that we faced is that the few adjudicators that are handling the matters, were starting to get overwhelmed because you're talking about really a couple of thousands per adjudicator
Right.
per year. And we had not anticipated that, those numbers and the level of interest. And so that could explain partly why some of the issues,
Some of the delays.
that have been talked about there. But then there's something we are doing about those numbers. There's some innovations that we have come up with, and maybe we'll talk about that. But that is one huge thing. I think the numbers, and that can be seen both from as a challenge, but also as a positive thing,
As a vote of confidence.
Yeah, exactly. Because I'll tell you, at the beginning, the thought was that we have these magistrates courts that are handling all these matters. Why not decongest the magistrates courts, remove the lower value matters from the magistrates courts so that they can focus on the bigger value items. And then these small value items, less than $1 million, those can be addressed by this court. So the thought was we would decongest of the cases that people ordinarily bring to court.
Yeah.
What we had not seen is that there are very many other people who had matters outside, who probably had decided it's not worth it. It's not worth taking my claim of 300,000, 50,000, 600,000.
To do a 5-year court process.
To be, it has to be a long process. So now suddenly people realize, I can follow up my 200,000.
Yeah.
I can follow up my 70,000. And so the numbers just went up. And then now, before the issue of the road traffic accidents also was determined,
Right.
if my claim is for 800,000, then let me go there because I know within 60 days,
Yeah.
This
I
will-
should be able to get my
So there was
judgment.
a sense of overwhelm.
There was a sense of that overwhelm. But it's something that we are addressing as we speak.
And you'll
right
tell
now.
us more about that. We do
Yeah.
need to take a break. I like this. Takima Pepe said, "Good morning. A wife damages her husband's car after alleging he's cheating. Is that small court if filed by the husband?"
I don't know. The value of the damage, I
Is
guess,
what matters. Like, remove all those other things.
Yeah.
What is the value of
Value.
But we'll come back and see if there's any
Value.
other questions. We're hosting Judiciary spokesman Paul Ndemo to talk about the small claims court. It's coming up to 7:30. So yes, I think, feedback was just the one from Takima Pepe. A wife damages her husband's car after alleging he's cheating. Is that a small claim court filed by the husband? Yeah. I'm sure you guys get a
Filed
lot
by
of
the
questions.
husband.
I'm sure there's a lot of, does this qualify? But I think you've broken it down simply. As long as there's a claim to be made, damages
Yes.
$1 million shillings below, then
Yeah.
you take it to court.
If there's a claim and you can prove this is your vehicle and this
that
was
this
done
is the
by this
person who
person, this is the
damaged.
person who did it. Yeah.
If it gets more personal, there's
Gets
other
more personal,
courts.
there are other areas you can go and have that resolved, not in the court.
Wait. Okay, but I was going through some of these things about the small claims court. So the idea that it's 100% virtual is great for inclusivity. It may also not be so good for inclusivity. How do we make sure that those who may not be super tech savvy but still have their claims heard?
Yeah, a very good question, and we actually did consider that. So what we have is where someone is not able to access the court virtually for the hearings, then they can actually go to the court premises itself.
Okay.
They will be enabled. They'll be connected to a gadget there, and they'll be connected to the court. So they just simply come to the court, they'll be connected, and their matter will be heard there.
Okay.
As simple as
that. So
that.
you go to your nearest court.
You
then.
go to the court that is hearing your matter. So if it is, unless it is remote.
Okay.
Unless it is remote. So let's say your matter is being heard at a Milimani small claims court, and you don't have access. You don't know, you're not tech savvy. You just go to Milimani small claims court. You will be set up there, and when the matter is being heard, you'll have access now to what is happening in court. Yeah.
Okay.
But then we have an initiative we call Mahakama Popote. Now, Mahakama Popote just means the court is everywhere. And what we have done with that is because of the sheer volume of claims in certain courts now, like Milimani, maybe like Kisumu, Kakamega, very high volumes, we have redistributed those matters to have adjudicators who are in remote places, who may not have as much volume as Milimani or in those courts I've mentioned, to listen to those matters.
Okay.
So you can be set up in Nairobi to hear your matter that is based in Nairobi, but the adjudicator that is hearing your matter is based in Loitoktok,
Right.
for example. Yeah. So that way, we've actually been able to, in a very creative way, work to decongest the volume and ensure that there is access to justice.
Right.
In fact, last year alone, not just on small claims, but a big portion small claims, we were able to deal with over 14,000 matters across the country just by ensuring that they were redistributed, across the country to, magistrates and adjudicators. Yeah.
There was an issue also that emerged. 2 weeks ago, on the last word, we were having a conversation with lawyers ahead of the LSK elections.
Yeah.
And one advocate stood and raised a concern and said, I'd like the next leadership of the Law Society of Kenya to address this matter. I practice a lot in the small claims court, he said, and he has an issue with the awards that are given by the adjudicators. So he says, I have spent time preparing for this particular case. I have represented my client, and then when the adjudicator comes and gives awards, I'm given like 50,000 shillings. It's like, surely. All the time and effort I've taken to do this, and sometimes even the case has gone beyond the 60 days, and then I only get 50,000 shillings after all my years of training and all my professionalism.
So interesting. My question was the opposite of that. I was like, our lawyers just making the courts too expensive.
That's the question that is actually emerging. Like, where do you strike the balance between?
Right.
So a lawyer coming into this court will expect that they're going to make a decent living out of representing clients here. And if they're not making a decent living, what is going to happen to the court?
I think very, very interesting. And I think as between the two of you, you seem to have got the middle ground. Because because the issue is, if you're coming there as a lawyer, you definitely expect that your fees is not going to be high. Because what I think many lawyers would thrive on here is the numbers. So if I've got many cases that are before the small claims court and I'm getting 20,000 here, 30,000 here, and the turnaround time is the 60 days, then it means in terms of, your fees, that may be something. But to expect that I will come and I'm representing a client and I'm going to get,
Millions.
$500,000.
I don't think so. I don't think so. So the court, by its very nature, is a court for small claims. So even the awards, one should properly expect that the awards that will come from the court are also not very high awards, and they have a limit. But should you have a problem, as a lawyer, that these awards are this a particular award is not commensurate with my case, then you have a right to appeal. You can go and appeal and say, no, this claim for me was, I think I should have gotten this amount, and this is too low, blah blah. You present your, you present your issues in the High Court, and the matter will then be heard there.
I have a radical thought, which was just like do away with the lawyers, but then my people perish for lack of knowledge. Like so many people will be unfairly disadvantaged because they lack legal representation. Because I'm assuming I'm going after my landlord, who has. They may not have legal representation in the small claims court, assuming we've been told no lawyers. But of course, they have lawyers, right? And then there's little old me, or I'm going after a former employer. For like
the power dynamics.
The power dynamics are just
Why do away with
the lawyers?
The radical
expense.
Was just the expense for people.
I agree. By the way, I am completely for that idea. Look, this court was meant to be radical like that.
That's true,
right? So it is seeking to get those people who feel that I will. Remember the other side we were saying, people who initially looked at the amount, the time, the costs, and were not going to court at all, are now coming to court, right? Because you have made it fast, simple, and affordable. Now, bring in any other intermediary and you are increasing costs. So remove intermediaries and you're just dealing with that. And if it's just being dealt by an adjudicator file and they're looking at, so you're saying that this person owed you this. In fact, remember the other day we were looking at just mobile money receipt. Alikulipa hii M-Pesa. Haya, na kuna SMS mliambiana utalipa hiyo nyingine lini? Na hakujibu. Sawa.
Hii simu ni yako. Hii ndio you had it, yes.
There.
That's
Simple.
it.
That's it.
Then we keep those matters that are those daily small disputes into the small claims court. So that then lawyers can go and practice elsewhere. But then, Your Honor, Mariam has given an example, two examples here. She has given one example of landlord and another example of former employer. Do those cases need to go to the small claims court? Rent disputes, employment disputes.
You're right.
So for employment disputes, we have an employment and labor relations court. Because if it's an employment dispute, then there are issues around there that have to be, they have to be dealt with and, adjudicated there. So the right court for that is not the small claims court. Those ones have to, because evidence has to be adduced, the employer must be brought in. So, I mean, if you're asking, you see,
claiming that I
resigned.
So if you're asking for something very simple, you're asking for some amount of money, and because if
I resigned, they didn't pay the last month's salary. Evil.
Something like that could work. Yeah, because that's a small claim. That's not a big issue you're looking at. But if there are issues about now you want the court to make an order for you to be reinstated, there are disputes about
the mode of termination,
all those kind of things, then you're starting to wade.
But I would even see that one for I wasn't paid for the last month. I feel like it still intersects with other issues. There's the claim of the money, but there's rights, there's
and that's why
you're contractually employed.
And that's why you want to really limit what is in the small claims. So as the name suggests, it is claims. So once now you start wading into contractual obligations of other rights, then we start getting into a bit of a tricky place.
So now do I know if my particular dispute can still go to the small claims court? Because I'm thinking my number one thing is efficiency and cost. Those would be the things I'm thinking about. So I'll be like, which one is faster? Is it small claims, or is it the employment tribunal, or is it the rent tribunal? And it's not called the rent tribunal.
There is the rent, yes.
It is called the rent. I thought it had like a bigger word.
Rent restriction tribunal.
Rent
restriction tribunal.
Okay, so then how do I know if my claim falls into either of these two tribunals or the small claims court? And then also, do the employment and rent tribunals have the same, for example, turnaround time as the small claims court?
Okay, so the issues of rent, if you are disputing because if there are now disputes to do with maybe not even the amount and other issues, then the right forum really is the rent tribunal. Because that one is one that has the proper jurisdiction, you know. But if you're coming to claim and say, I paid this amount of money, I just want to get this money back.
Deposit.
Like
Then,
deposit.
Yeah, deposit. You know, deposit. You are not disputing other things.
Okay.
Then that would be it.
Okay.
Now, the Employment and Labor Relations Court, that's a typical court. Let me call it typical, for the lack of a better word. The turnaround time is certainly not 60 days, because that now has to come and queue with the rest of the cases that are there. That court has got it's subject to more procedure. There are, you know, more processes that are done there. Small claims court is it's supposed to be simple, direct.
Right.
In fact, in some jurisdictions that we know, like a place like Zambia, Uganda, you get your judgment on the spot. Because it is, did you not, whatever, 10 minutes, finish, go, finished, you know. So there are certain claims and rights that you have in some matters that cannot just be determined that speedily. There needs to be some evidence given and all that. That is why if you have got an employment matter that then could, you know, drift into some level of complexity, then it's better it just goes to the Employment and Labor Relations Court. And we have those courts, both at the magistrate level for maybe lower claims to very high claims at the Employment and Labor Relations Court at the High Court level.
Okay.
Yeah.
I just had a morbid thought actually. What happens if someone passes on while there's a case going on, whether it's 60 days or, you know, when there's no timeline? Yeah.
So what happens is when you pass on, then you leave what we call an estate. Let me think of a simpler way to explain
your
that.
Successors.
Your successors can take over that matter. Yeah, they can take it over. They know there was this case that was filed. This person died. If you left a will, then there are people who are executing your will or administrators. Those are the people that would then come and continue that particular case on your behalf. So someone can continue that case on your behalf if you're dead.
Okay. What if you're the defendant?
If you're the defendant in that
case.
Yeah, well then.
Right?
Yeah.
So it means that the people who are inheriting,
But,
you're also
yeah.
inheriting your court cases.
Yeah, liabilities.
You inherit,
Actually,
you inherit assets and liabilities.
It's assets and liabilities, it's true.
Yeah.
It's true. Because once this person continues the case, then they'll be like, we've gotten judgment, we want now to execute and get, we are supposed to get 300,000. Who is going to pay us this 300,000? This person died
The estate
last week, so it's the estate. So we come after this person's estate and we get that.
Okay.
I don't know what I'm hearing. I could be hearing wrong. Courts work with supervision and templates and direction. This one almost sounds like not whatever goes. I'm just wondering if there's a template or direction that can guide either how it's practiced, how people can make claims, what people need to know. It does sound very case by case, which I get that it is. I'm a rules person.
You want a format?
I want a format and a template.
Do you want a form? Just a form. Tick these boxes.
No, it's not a haphazard court. I hope that's not what I'm communicating. It's not just come, say what you want to say, and then, no. It's a very formal, organized
The
court.
OCD person in
Oh,
me is
no. No, it's a very organized court. It's just that the typical, very restrictive manner in which our ordinary courts operate do not bind this court. In fact, one of the innovations we are working on to get into this court, and you did mention it in your tweet, is having a template.
Yeah.
A template for judgments. Because the matters are relatively simple. So instead of going into someone writing 10, 15, 30 pages of, this, have something that is more or less standard. I've had you, so this is the party, what is the claim, what is the issue? This is the issue. What is the evidence? This is the evidence. What have we decided? We have decided this. So that an adjudicator can, in a very simple way and very fast, be able to just determine and say, this is it, and
so
we
that
move
has been
on.
introduced or is being introduced?
That is being introduced. We are working on it.
You see, my question wasn't so far
But
off.
that is as far as judgments are concerned. But in terms of a process, it's very organized. There is an order
You can't
to
find
how
an
you come.
adjudicator on the road and say, by the way.
Yeah, no, you can't do that.
Kuna
You
mtu ako
can't
na
do
dini
that.
yangu.
Okay, but that's
Nitamleta kesho. No.
Okay,
There is
that's
an order to it.
Yeah, I know. One of the questions that we must respond to is how the judiciary communicates to the people. First of all, creating awareness about the existence of these courts and how to access it, and how to handle complaints from people who feel I have a case that's taken too long, and so on and so forth.
Yeah.
Before you come to answer that, because I'll ask you that question, show me the difference between the small claims court and the other modes of accessing justice easily. For example, we have the tribunals. We have so many tribunals. The Rent Dispute Tribunal is one of them. We have HIV/AIDS Tribunal. We have Sports Tribunal, and so on. And then we have the alternative justice system, the AJS courts.
Okay.
So at what point do I take a case to an AJS court, and when do I bring a case to a small claims court?
Right. So that's a good question.
Yeah, very, very good question indeed. So the small claims court is a court that handles matters that are below $1 million. I think that we have settled. So generally speaking, debts, issues on a tort where someone has caused damage, to an extent, something like a service delivered, you go to that court so that that matter can then be, heard and expedited. You then have magistrates' courts. Now, magistrates' courts would hear all other cases. We have the civil claims that would still be heard in the small claims court, but of a higher value. So the same thing can be heard in the magistrates' courts. And the different magistrates have got different limits in terms of how much money. So a new magistrate at the lower rank, who is a resident magistrate, can only listen to matters up to 5 million.
Okay.
So if you have a claim that is beyond 5 million, then you go to the next level of magistrate. So you've got a resident magistrate, senior resident magistrate, principal magistrate, senior principal magistrate, chief magistrate. A chief magistrate has got jurisdiction to hear matters up to 20 million. So any matter, any dispute, whether it is of a commercial nature, a civil nature, within 20 million can be heard by the magistrate. Anything above 20 million has to go to the High Court. So same dispute, different amount of money. It could even about land, whatever. If that value is different, then it goes.
Is there a dashboard with this information? Is it similar to what you asked?
Just
because that was a really good breakdown. How would somebody know in terms of awareness? And
then still the question on now the alternative.
So now, the alternatives that we have. First of all, the alternative justice system is something that we are championing as the court, because we have that mandate and responsibility under the Constitution. And so we encourage people and say we actually have other forms of dispute resolution. You do not have to bring everything to court. So settle those matters outside. And we have been working very closely with county governments. We have helped to set up what we call county action plans for alternative justice disputes in those 12 counties. And you have got stakeholders come together, elders and just different groups, and they are sensitized and they're able to resolve matters on their own outside. Then you have got something we call the court annexed mediation. So this is now mediation, but you come to court first. So when you come to court, you have a matter, let's say you're having a dispute on succession. You're trying to, the property that was left, let's say by your parents or whoever is deceased, you're having a dispute about that. The court asks you to, can you go and try mediate on this issue? We even appoint for you a mediator. You go and you sit and discuss. Should you agree, which we hope you do, you come back to court and you record a consent. We say you have agreed. and that matter is resolved there. So we don't have to go into the long hearings trying to, prove that I was so-and-so's son or daughter and issues, and I should have gotten this. That is, and actually from this court-annexed mediation, since we started it in 2016, we have been able to resolve disputes using that mechanism alone of 100 billion shillings, just within that period. So that is a mechanism that we are continually encouraging people to actually just get involved, because they are really, really helping us.
Let me give you a small case study
Yeah.
before. I know you're moving on to another alternative justice system, right? I just, so that we can use a practical example to go through the system. Okay, Eric gave me 50K before Christmas. I asked, but it was not.
Is that
we did
factual
not-
or it's
No, it's theoretical. I wish it was factual. But we didn't say explicitly it was a loan. Now he's asking for it back. I thought it was a Christmas gift. Where do I begin? Can we just go the mediation route? Do we find, there's the other one, there's a mediator and there's the other one for bringing people together. You know what I'm talking about, guys? There's that one. Or small claims court, like that. Yeah, so it's a mediator, a court annex mediation. I'm really forgetting the other term, but it'll come to me.
Yeah, there's
yes,
conciliation,
there's the
mediation.
mediation and
Talk about arbitration.
arbitration, that's the word. Yes, arbitration, or just go to, or does he just go to small claims court? I would prefer mediation. I think
Yeah.
we'd have a better outcome.
Actually, mediation is better, really. I mean, we are the court. We have grown up in this very formal structure. This is what we know. This is what we inherited from the colonial government. It's the system that is in all Commonwealth countries. So it is what we are used to. But we are the same people that are championing these alternative justice systems, because the Commonwealth system that we have is what we call adversarial. It is you versus me. So you win, I lose. Or I win, you lose. When you have mediation is a win-win. Because mediation, we will come and we will talk. We may not be happy with each other at the beginning, but we will talk. Eventually, you will get to understand. Eric will get to understand that you thought it was
A gift.
it was a gift. But for him, it's like, no. I actually borrowed this money. It's because you came to me and you look desperate, so I borrowed the money I gave to you. So when you continue engaging, you'll be like, okay, I didn't know that is what it was. So what we do, I cannot afford this amount of money. I can only afford 30,000. Would that work? Okay, give me the 30, and then this other 20 will, we can discuss
Or
later.
you pay it over time.
Or you pay it over time.
We have about a minute. I know there was other things that you
There was a
were
question
Yeah.
about how to communicate.
Yes.
So part of the communication is what we are doing here. We are on the airwaves, we are talking about this, we have our websites, but we also have a very big day coming tomorrow, the Judiciary Dialogue Day. And this is open in all our 145 court stations across the country. We are inviting wananchi to come there, ask questions like this. I have a claim, do I bring it to the small claims court? Do I go to this tribunal? What alternatives exist? Give us feedback about our services. We will explain our processes. This is how we do this. This is what we do. In these particular matters, if you have an appeal, where do you go? Because from the small claims court, we go right up to, actually we start from the tribunals. Okay. We go tribunals, we have small claims, we've got the magistrates courts, we've got the high courts, employment court, environment court, court of appeal, Supreme Court. How do you access all these courts in order for you to, make good your right? So we are inviting everybody across our court stations in every single court, from Lodwar all the way to Lamu. Yeah. We'll be having our courts present to listen, to give, what we have done, our processes, and also receive feedback.
Thank you.
Yeah.
Just one final question. This is a lawyer, Ben Chakala, asking, as a practicing advocate, I think breach of contract cases should be taken, removed from small claims court. What's your take?
Well, I think it depends on the value. I really think it depends on the value, because again, if it's something that is within the threshold, I see no reason why it cannot be within the small claims court. If you're claiming 100,000 breach of contract, you take it. Where do you take it?
Yeah.
How do we that official Judiciary Dialogue Day? How do we become a part of it? just one last time?
Oh, yeah. I mean, we are all over the country. We are here in Nairobi. We're in Milimani. So go to court.
Yeah, but also have a
Come
pinned,
to court.
have a pinned dashboard somewhere on
Okay.
your socials, on our website, where somebody can just open and know.
Just get,
5 million. Oh, it says this.
Easy
Oh,
information.
20 million. This. Yeah, but all
Fantastic.
the best
Thank
and
you.
please, people, it's
Thank
across
you.
the country, so hopefully
Everywhere.
it's everywhere. Please
Yes.
get information. Paul Ndemo, Judiciary spokesman, has been talking to us about navigating small claims courts. In the next hour, actually 2 hours, we're going to have a conversation around chronic illness. We're going to start with a warrior. She's called Wendy Gikono, Living Brave, Life of an Autoimmune Warrior. It's coming up to 8 a.m. We'll have that conversation in just a moment.